During the Katy Perry federal court dispute, attorneys argue about an odd detail. After Katy Perry, a music star from the U.S., lost a protracted court dispute in which it was determined that her company had violated a trademark, her lawyers and those of a Sydney designer are having trouble reaching a consensus on what qualifies as apparel. Katy Jane Taylor, a self-described Aussie battler from Sydney, filed a lawsuit against the I Kissed a Girl singer in the federal court on grounds of trademark infringement for the sale of clothing, including t-shirts and pajamas, in Australia. Ms. Taylor, a mother of two, has used her birth name, Katy Perry, to run a clothing line since 2006 and has owned the trademark in Australia for more than 10 years. Catherine Elizabeth Hudson, the singer, was sued by a Sydney fashion designer who claimed she violated her trademark by using one that was substantially identical to or deceptively similar to hers. According to Ms. Taylor, the musician has been selling merchandise under the trademark in Australia since at least 2013, both at her concerts and in stores like Myer and Target. Following the protracted trademark fight, Justice Bridget Markovic issued her ruling in April, describing it as a tale of two women, two teenage dreams, and one name. While Perry and her company, Killer Queen 100, had their counterclaim dismissed, Ms. Taylor had partially prevailed in her allegations. On Wednesday, when Justice Markovic rehearsed the case, Ms. Taylor's attorney, Christian Dimitriades SC, informed the judge that the parties were unable to reach consensus on 5 issues. The first area of disagreement arises in the definition of clothes on page 2. It affects the scope of the declaration that is imposed, Mr. Dimitriades stated. According to Mr. Dimitriades, the definition of clothing does not specifically mention dresses as an article of clothing. He warned the court that some examples in this list may fall between the cracks. Justice Markovic stated that she would need time to consider the arguments before issuing any orders, which she would do in her chambers. In the judge's decision, Perry was found to have violated trademark rights in social media posts from 2013 and 2014 promoting her prismatic tour. The trademark was used in good faith, according to the judge, thus the artist did not need to pay the Sydney designer anything. Additional infractions were discovered at pop-up shops in Sydney and Melbourne as well as during the singer's prismatic tour of Australia in 2014 and 2015. A website for the apparel brand Bravado was deemed to have violated the trademark, according to Justice Markovic. Perry's business, Katy Perry, is accountable for the specific infractions. The assertions made by Ms. Taylor that 8 instances of infringements involving clothing purchased from Myer, Target, and Cotton On happened after 2013 were rejected by Justice Markovic. Prior to the 2018 Perry's Witness Tour, Justice Markovic rejected charges that clothing sold on Amazon and eBay violated Ms. Taylor's trademark. Ms. Taylor started creating clothing in November 2007, and in May 2008, she sold them at Sydney markets after they had been introduced at a school charity event. In 2007, she had previously registered Katy Perry as her company name and domain name. In a YouTube video message to the celebrity in 2009, Ms. Taylor made the legal dispute public. Steven Jensen, Perry's manager, expressed his opinion that the matter had been blown way out of proportion in response through email. At a later time, Justice Markovic will decide how much Katy Perry is required to pay in damages.